Part 1 of Chapter 5 in the Constitution of Kenya outlines the principles of land policy, the classification of land, and the establishment of the National Land Commission. Here's a summary of each section. 60. Principles of Land Policy. Article 60. Land in Kenya should be held, used, and managed equitably, efficiently, productively, and sustainably. The principles of land policy include equitable access to land, security of land rights, sustainable land management, transparent land administration, conservation of ecologically sensitive areas, elimination of gender discrimination related to land and property, and encouraging community-led initiatives to settle land disputes. These principles are to be implemented through a national land policy developed and reviewed regularly by the national government and through legislation. 61. Classification of land. Article 61. All land in Kenya belongs to the people of Kenya collectively as a nation, as communities, and as individuals. Land in Kenya is classified as public, community, or private land. 62. Public land. Article 62. Public land includes various categories of land such as government-owned land, state organ-occupied land, unclaimed land, government forests, water catchment areas, rivers, lakes, and more. Public land is held by county governments in trust for the people resident in the county and administered on their behalf by the National Land Commission. Legislation is required for the disposal or use of public land. 63. Community land. Article 63. Community land is held by communities identified based on ethnicity, culture, or similar community of interest. It includes land registered in the name of group representatives, land transferred to specific communities, and other land declared as community land by an Act of Parliament. Community land should not be disposed of or used except as specified in legislation that defines the rights of individual and collective community members. 64. Private land. Article 64. Private land consists of land held under freehold or leasehold tenure, and any other land declared as private land by an Act of Parliament. 65. Land holding by non-citizens. Article 65. Non-citizens may only hold land on leasehold tenure, and any such lease should not exceed 99 years. Legislation may be enacted to make further provisions regarding land holding by non-citizens. 66. Regulation of land use and property. Article 66. The state may regulate land use and property in the interest of various public concerns such as defense, public safety, land use planning, etc. Parliament shall ensure that investments in property benefit local communities and their economies. 67. National Land Commission. Article 67. The National Land Commission is established to manage public land on behalf of the national and county governments. It has various functions, including advising the national government on land policy, conducting research on land and natural resources, investigating land injustices, and monitoring land use planning. 68. Legislation on land. Article 68. Parliament has the responsibility to revise, consolidate, and rationalize existing land laws and sectoral land use laws. Parliament is also required to enact legislation to address various land-related matters, including land holding acreage, land conversion, matrimonial property protection, public land protection, review of grants or dispositions of public land, and protection of dependents of deceased landholders, among others. Part 2 of Chapter 5 in the Constitution of Kenya focuses on environmental protection and the sustainable utilization of natural resources. Here's a summary of each section. 69. Obligations in respect of the environment. Article 69. The state has various obligations to ensure the sustainable exploitation, utilization, management, and conservation of the environment and natural resources. These obligations include equitable sharing of the benefits, achieving and maintaining a minimum tree cover of 10% of the land area, protecting indigenous knowledge and intellectual property related to biodiversity and genetic resources, encouraging public participation in environmental management, protecting genetic resources and biodiversity, establishing environmental impact assessment and monitoring systems, and eliminating environmentally harmful processes and activities. The environment and natural resources should be used for the benefit of the people of Kenya. 69. Duty to protect and conserve the environment. Article 69. Every person has the duty to cooperate with state organs and others to protect and conserve the environment and ensure ecologically sustainable development and use of natural resources. 70. Enforcement of environmental rights. Article 70. If a person alleges that their right to a clean and healthy environment recognized and protected under Article 42 is being denied, violated, infringed, or threatened, they can apply to a court for redress. The court may issue orders or directions to prevent harmful acts, compel public officers to take action, or provide compensation to victims of environmental violations. The applicant does not need to demonstrate any personal loss or injury to seek redress. 71. Agreements relating to natural resources. Article 71. Any transaction involving the grant of rights or concessions for the exploitation of Kenya's natural resources, whether by the national government or any other person, requires ratification by Parliament if entered into on or after the effective date of the Constitution. Parliament is responsible for enacting legislation specifying the classes of transactions subject to ratification. 72. Legislation relating to the environment. Article 72. Parliament is required to enact legislation to give full effect to the provisions of this part, ensuring the protection, conservation, and sustainable management of the environment and natural resources.